בוקר טוב לכולם. אני לא מדבר עברית, אני לא יכול לדבר עברית. הייתי מעדיף לדבר בעברית, אבל אין ברירה. העברית שלי לא כל כך טוב, אז אני אדבר באנגלית. As Amichai told you, I've been a clinical teacher at Yale Law School for 42 years. My children look at me and say, "That's a life?" And I say, "Yeah, it's a good life." I thought that I would talk for a few moments about some reflections that I have about clinical education in Israel and in the United States, some differences, but some common issues that face all of us as clinicians. And then perhaps we could have a conversation for another half hour or so about some of those issues or other issues that you want to raise. I had come to Israel several times, both as a child and as an adult. But in 1992, when I had a sabbatical coming up, and Aaron Barak was teaching then at the Yale Law School for his small time in the fall, he said, "Why don't you come to Israel for your sabbatical?" And I said, "Okay." And so I came, and to my surprise, he was at the airport to pick me up and brought me home. And I actually lived with him and Elika for a while until they found me an apartment. And then I spent that semester at Hebrew University. Clinical legal education in 1992 barely existed in Israel. At Hebrew University, Baruch Yahu Lifshitz, a member of the faculty, had a group of 8 or 10 students whom he sent to legal aid offices in Jerusalem, and he met with them every 2 weeks or so just to see how they were doing, and that was the clinic. There was really no instruction going on in the law school. The law school did not see it as part of the educational curriculum, and it was for students who wanted to do something practical. That was an opportunity. At that time, the only other clinic I was aware of was Kenneth Mann at Tel Aviv, doing a criminal defense clinic with students. And as far as I knew, that was it in Israel. So it's quite incredible in 2012 to see this room full of people, and you're only a small part of all of the clinicians in Israel. So clinical legal education has really grown in a very dramatic way in Israel. In 1996, I spent sabbatical at Haifa University, and Haifa was a new law school at that time. And Ilan Saban was doing what Baruch Yahu Lifshitz had done at Jerusalem, which was he had a group of students and they were placed in legal aid and public defender offices, and he had a class once a week in which they talked generally about lawyers and society and things that Ilan was interested in, and that was it. And if you look at the clinics today at Jerusalem, the clinics that Sharon developed there, and she's now moving her skills to the IDC to develop a clinical program there. And if you look at what's going on at Haifa with all of the clinics that Ronit Alperin has helped develop, and if you look at the clinics at Tel Aviv, where there are now 8 clinics, 9, clear, 8? 8 clinics, a huge program. It's really quite rewarding for me to see the growth of clinical education in Israel. I would like to think that it's because, not just because Israel likes to copy the United States, everything good and everything bad. I don't know whether the Republicans are copying Likud or Likud is copying the Republicans, but we tend to copy each other in various things. But the growth has been really remarkable. There are some comparisons which I need to acknowledge, because when I talk about clinical education in America, I understand that what we do is not transferable here in all of its elements. For example, in the United States, law students have already been to college for 4 years. So they've already had a 4-year liberal arts education before they come. On the other hand, none of our students have been in the Army. We now have some veterans from Iraq and Afghanistan, and I'm one of 4 people on our faculty who did military service in the United States. So every semester, the 4 of us take the 6 or 8 veterans out to an Irish pub for Guinness and talk. While your students haven't had the 4-year education that our students have in college, they've had a different kind of experience which can be maturing and expose them to things that my students are not exposed to. But that's a major difference. Because our students have all had 4 years of college, they come to law school as a graduate school, and they have much more selection of what they're going to study. Very few required courses and many electives. And in my law school at least, after the first semester of law school, students can start electing courses. So we get first-year law students in the clinics. Every spring semester, we have half the first-year class come to the clinics, and then the other half usually comes in the first semester of the second year. So for us, clinical education is an integral part of their law school. They move back and forth between the clinical courses and academic courses. And as they walk that educational pathway, they make connections between theory and practice that are harder to do when students are coming to clinics for the first time at the end of their law school career, and it's seen as sort of a transition into the world of practice. We have student practice rules in the United States that allow students to appear in court, to represent clients, to try cases before judges, before juries, to argue appeals in appellate courts, to handle cases in administrative forums and administrative courts. That means that we have to spend a considerable amount of our time teaching them how to do that. That detracts from our ability to focus on issues of social justice and public service, and because in Israel you don't have to teach students to do that because you don't have student practice rules. So what we do in our classrooms and our supervision is different. We struggle to maintain the students' focus on why we're doing what we do in the public service obligations of law schools and issues of social justice, and because we're spending a lot of time teaching students actually how to do things with clients. For you, the struggle is finding ways to give students responsibility even though they're not going to be handling the cases in court. Finding ways for them to help you prepare to go to court or to wherever your practice venues are, and to go with you, to critique with you afterwards. It's a different kind of teaching. Our students don't take 7 or 8 courses a semester. Our students take 3 or 4 courses a semester. So they have lots of time to spend in the clinic. So we expect students to spend a minimum of 15 hours a week working on cases. That's obviously not possible in a country where they're taking 7 or 8 courses a semester and they have jobs. None of our students have jobs. Our students are all full-time students. So those are all differences that make the way you address clinical education different here than you would in the United States. But there are common issues, I think, for all of us, and they are issues that relate to what we teach, how we teach it, and professional issues for us as clinicians. So those are the 3 things I want to talk about a little bit with you, and then get your views about them as well. In October, there was a symposium at the Boston College Law School about clinical legal education. And the whole point of the symposium is, what should we be teaching and how should we be teaching it? And I had a debate with a young clinician from University of Pennsylvania Law School who teaches a transactional clinic in which they do kind of different kinds of business work. They don't just represent poor people, they represent people who could actually afford lawyers. And his position was that we should forget about social justice, that in the current economic situation, our students are having trouble finding jobs. We need to teach them skills so that law firms will say they can come in and they already know how to do things. So he said, my role as a clinical teacher is to teach students legal skills and to prepare them for the practice of law. And my response was to ask the question, is social justice still relevant? And to argue strongly that the roots of clinical legal education were rooted in social justice, that we thought that law students ought to be exposed to poverty and injustice in the world, and that the clinics are the way to do it, that we should be taking students literally out of the law school into the world so they could see how law affects people and who gets the benefit of law and who doesn't, and what the role is of lawyers in helping them. So that's sort of the first debate that's going on in the United States now. Should we be focusing on skills, legal skills training, or should we be using the opportunity we have to actually represent clients to instill in students some broader social values of serving the poor and challenging injustice, and discussing with them the potential of law either to achieve social change or its limitations in achieving social change. They also need to know that there's some things that lawyers can't do. So it's an ongoing debate in the United States, whether we should be focusing on skills or focusing on social justice. Obviously, I have a point of view, which is the skills are incidental to the broader educational mission that we have, which is to teach students to be socially responsible, ethical lawyers, and to do pro bono, to take jobs representing poor people and vulnerable populations, to be concerned about how environmental degradation affects poor people in poor communities, not just rich people in their sailboats on the water. But it's an ongoing debate in the United States. So that's one. A second debate is, how should we be doing it? Should we be representing individual clients? Is it possible litaken et ha'olam, one client at a time? Or should we be doing impact litigation, law reform, legislative advocacy, trying to have a larger impact on the society? Those who argue in favor of what I just described, of broader impact work, say that as university and law college teachers, we are a very scarce resource. There are very few of us, and it's not right for us just to focus on individual clients. We should use the resources of the institutions where we work to have a broader social impact. And for those like me who, if I'm sitting across the desk from a client, I know what to do. If I'm looking at the world and trying to change it, I'm not sure I know what to do. So, and also that for students having individual clients with whom they have a personal relationship and for which they develop a sense of responsibility, that's an important aspect of what we should be teaching. And of course, the answer is we should do both if we can. The little cases, I don't like to call representing individual clients little cases, because for the clients they're very big cases. But when you represent individual clients, very often the students can handle most of the case from beginning to end. When you do the larger cases, they extend from semester to semester, from year to year, and there's the pedagogical challenge of how you help students learn from only seeing a piece of what a broader legal campaign is. But that's another conversation, and in our program we do both. We have clinics that do law reform, litigation. We have a clinic that does legislative advocacy like Abiad's. We have clinics that represent groups of people, and we also have clinics like mine that we represent individual refugees seeking asylum or individual poor people who have legal problems. A third debate is whether we should be doing what lawyers do, which is either big cases or small cases, or we should be engaged in law and organizing, what American clinicians have come to call social mobilization lawyering. The premise of that argument is that lawyers will never help poor people. Only poor people can help poor people. They have to get themselves together, organize themselves into to have some political clout. That law school clinics shouldn't be doing these cases at all, not little cases, not big cases, but they should be working with community organizations, different kinds of communities. In New York, there's a clinic that represents Bangladeshi taxi cab drivers in New York City. And there is a Bangladeshi woman lawyer who is at City University of New York Law School, who's the lawyer in that clinic. And that group, that community of Bangladeshi taxi drivers, have many interests in common. But she has really accomplished quite a bit for them by working with them. She tells a story that one time she was talking to a group of Bangladeshi cab drivers, and they asked her, why isn't she married? Why isn't she home with her husband and children? And she said, I said to them, are you looking for a wife or a lawyer? And they said a lawyer. So, but that's an interesting project. Restaurant workers in New York, most of their income comes from tips. They're really exploited by restaurants and mistreated, and the unions don't organize them, and they're not really covered by the labor laws. So they've been working with an organization, the Restaurant Organizing Committee, working with restaurant workers. And that's what they do. They say, we only will provide legal help to people who belong to organizations, who are part of a movement, and we will also help the movement get itself together and do legal work for it. And of course, the rest of us who are doing either big cases or small cases say that's not really what lawyers do. We're not trained to be community organizers. We're trained, you know, our special skill is that of being a lawyer. And there's substantial writing about that, about what's the role of a lawyer in social movements. At Tel Aviv, some of you may know, Itai Svirsky has been instrumental in organizing Koach Le'ovdim, which is an alternative union to the Histadrut, which instead of an elite top-down union like Histadrut, in which there is no union democracy, to one that comes up from the bottom up, from organizing low-wage workers for whom the Histadrut has not been an effective advocate. And that conversation is going on in the Tel Aviv clinic now, the same one that we're having in the United States. How can a lawyer be an organizer? And I think Itai and his clinic are showing how that can happen. Those are the three different kinds of ways that we think about what should we be teaching and how should we be teaching it. And the arguments are actually quite interesting and heated. And at least in the United States, when a group of clinicians get together like this, we are really quite vigorously arguing with each other about what it is we want students to learn and what our role is as a law school clinic in the society. A third issue that has, which is about us and not about the students or the clients, has to do with our status, job security, and pay. I don't know if you have that problem here. So for, during the time that I've been a clinical teacher, in the beginning, when I came to Yale, I would get appointed 1 year at a time. My salary was very low. There was no place for advancement, and I had no way of thinking that 42 years later I would still be doing this. And so for the clinicians in the United States, they formed a Clinical Legal Education Association, which is like a union of clinical lawyers. One more difference, in the United States you don't need a doctorate to teach because law school is a graduate school. So most American law teachers don't have doctorates. Increasingly, law professors, especially those that are on the academic side, are having PhDs in economics or political science or philosophy. The JSD is not a degree for Americans. In the JSD program at Yale, the 20 or so students are all from foreign countries. There are no Americans in the program because we don't need a doctorate. And that means that in my clinic, I not only teach the classes, I also am the lawyer of record on the cases and supervise the students. So that's a difference. But for us, we went through a long process over a period of about 20 years trying to advocate for ourselves that we needed to have a faculty appointment. We eventually were able to persuade the American Bar Association, which provides accreditation for the law schools, to pass a rule that clinical teachers had to have a law school status, job security, roughly similar to what academic professors had. In my law school, that ended up being a clinical tenure track where we could have room for advancement to the point where I became a professor, clinical professor, with a salary roughly equivalent to what the academic professors were making. But that was an example of community mobilization. The clinicians got together and really agitated for it, formed an organization, made proposals, and eventually it happened. We don't have a Council of Higher Education in the United States, so each university and law school could do its own way. In some law schools, clinical teachers like you, end up being on a regular academic tenure track. They're expected to write, which is a problem because writing is not what we do. We are teachers of practice, but we have found a way to write about what it is that we do. And for those of you who have not seen the Clinical Law Review, which is published at NYU Law School, you should look at it. It's a law review that comes out 4 times a year and has articles by clinicians, articles about clinics, about clinical supervision, clinical teaching, ways of teaching particular kinds of things. It's a law review that advances our project rather than taking us away from our project to engage in over-theorized, esoteric, academic writing that I can never understand most of it. And then you have to convince the faculty when they're voting on whether or not you should be promoted within the clinical system that what you're writing makes good sense for what we do, because they don't understand, just as we don't understand, at least I don't understand a lot of what they're writing, they don't understand a lot of what we're writing, because my academic colleagues have almost no interest in what lawyers or judges do. They're interested in economic theory and why the law ought to follow their economic models, however realistic or unrealistic they may be. So those professional issues sometimes occupy too much of our time. I mean, there was a point in which all we were talking about was ourselves and not about the clients and not about the students. So the pendulum has swung back now, and we're back to focusing on what it is that we're teaching and how we're teaching. But if you can't see yourself doing this 10 years, 20 years from today because of the lack of status or job security or room for promotion or decent pay, then that's something that you really need to spend time on and to focus on. And you need to do it, I think, as a group. So although I'm suspicious about community mobilization and community organizing by lawyers, I think that we can organize ourselves to make things like that happen.